Namaste. So we were discussing the Mediation Act of 2023, and in the today's session we will discuss on Chapter 9 of Mediation Act 2023, which focuses on the mediation service provider. So Chapter 9 of Mediation Act 2023 focuses on the crucial roles played by the mediation service providers and mediation institutes in the mediation landscape. Mediation service providers and institutes are the backbone of the mediation system, ensuring that the mediation is conducted smoothly, effectively, and in accordance with legal and ethical guidelines. So in India, we have n number of mediation service providers who are providing the services, and the motto of all the mediation service provider is to resolve the disputes amicably, and the second primary object is to reduce the burden of the courts. This chapter outlines the definition, functions of the mediation service provider, and the recognition process for these entities, highlighting their importance in maintaining the efficiency, professionalism, and ethical standards of mediation process. So we'll move on to the discussion of section 40 of this chapter. So section 40 of the Mediation Act 2023 defines what constitutes a mediation service provider and outlines the recognition process by the Mediation Council. This section ensures that various entities involved in conducting the mediation are officially recognized and comply with standard set by the Act. So mediation service provider includes a body organization conducting mediation under the Mediation Act 2023. It must comply with the rules and regulation set by the Act. So basically, its mediation service provider is a body or organization which is conducting a mediation, but it should be recognized by the council or by the authorities established under the Legal Services Authority Act. It may be National Legal Service Authority or state legal service authorities, or it may be recognized by court annexed mediation center or notified by the central government. So, and also sometimes, see, there are certain body or organization which are recognized by the legal service authorities, by either by the state legal service authorities or by national legal service authorities. So such authorities, or there are certain mediation center which are annexed to the court. So basically such private institute mediator center which are annexed with the courts are also come within the purview of mediation service provider under section 40 of the Mediation Act. Or sometimes it may be recognized or notified by the central government. So such authorities or such private mediation centers are also come within the purview of the mediation service provider. So recognition process, coming to the recognition process, how the council or the authorities or court annexed mediation center should recognize the mediation service providers. The council specifies, so basically the council is not yet established because the act is not yet in force. So once the council is established, so it has the power to specify the manner in which the mediation service provider should be recognized. And it may also lay down what all are the requirements that the mediation service provider should comply with. And it may also it has the power to lay down the standard and guidelines with respect to the mediation process as well. So this is how section 40 is been designed, which provides a comprehensive framework for identifying and recognizing the mediation service provider. Basically, this provision or this chapter is included with an intent to provide the sanctity or authenticity of mediation through a private mediation institutes. So by including the various entities and specifying automatic recognition for certain bodies, like that the private mediation centers which are annexed with the legal service authorities or court annexed or by notified by the central government, such private institutions should have a sanctity, and they should also follow a standardized procedure in resolving of a dispute. And this empowers the private mediation institutes to indulge in mediation, and even the parties will be more happier to resolve the disputes through private mediation centers as well because of the scarcity of time. So the parties may even go through the private mediation institutes which are established in their zones for the resolution of disputes amicably. The next section, section 41, discusses about the functions of mediation service provider. So this section 41 details the duties of mediation service provider. These functions are pivotal for maintaining the integrity, efficiency of the mediation process, outlining the clear responsibilities, ensuring the mediation service provider play a crucial role in fostering a professional and ethical mediation environment. So basically, there are 6 functions are been enshrined to the mediation service provider. So first one, accredited mediators and maintain a panel of mediators. So accredited mediators. So accreditation involves evaluating and certifying the qualification, skills of mediators to ensure they meet the required standards. And maintaining the panel of mediators would result in keeping an updated list of accredited mediators who are available to conduct a mediation process or mediation sessions. The second function is that provide the services of mediator for conduct of mediation. This function ensures that whenever a mediation process is initiated, a qualified mediator from the accredited panel is assigned to the case. This assignment can be based on the mediator's expert or his availability or on the basis of nature of dispute. So this will move on to provide expertise or the availability and the nature would result in more dispute resolution, because it would lead to easy resolution of dispute. Having an expertise or a subject matter expertise would be easier for such mediator to guide the parties in an appropriate manner and facilitate them for amicable resolution of dispute. The third function enumerated to mediation service provider is to provide all facilities, including secretarial assistance and infrastructure for efficient conduct of mediation. This ensures the mediators and the disputing parties have access to the necessary resources such as mediation rooms, administrative support, communication tools, and any other logistic support required to conduct mediation smoothly. The fourth function enumerated is promote professional and ethical conduct amongst the mediator. Establishing and enforcing a code of conduct for mediators, organizing training sessions, and monitoring the adherence to ethical guidelines to maintain the integrity and credibility of the mediation process is must. And this maintaining of the credibility is the primary function of all the mediation service provider. Until and unless we have a ethical code of conduct or professional of code of conduct to be followed by the mediators, so we cannot say that the mediation is successful. So it requires a professional code of conduct is required to be followed by the mediators, and making the mediators to follow is the function of the mediation service provider. This mediation service provider is also have a duty to facilitate registration of a mediated settlement agreement. So we have already discussed section 20 of the Act, which provides for registration of a mediation settlement agreement. That is, if once the parties have reached to a mediation settlement, with the help of mediator, the parties draws a mediation settlement agreement, and that mediation settlement agreement, it may be, because it is an optional, so the parties may register that with court or lok adalat or the legal service authorities by means of section 20 of the Act. So registration of the settlement agreement leads to or ensures that the mediation settlement agreement are legally recognized and enforceable. Earlier, whenever there used to be, before the enactment of this legislation, whenever there used to be like the settlement of disputes by means of the private mediation centers, it was very difficult to ensure that the settlement agreement to make it more enforceable. Now with this process, that the process of registration of a settlement agreement with the authorities ensures the enforceable mechanism and having sanctity to the such mediation agreement, settlement agreement. Then any such other functions as may be specified by the council or by the central government, so as may be specified, such the mediation service provider should follow such functions, that to undertake additional responsibilities as may be specified by the central council or by regulatory authorities, adapting to evolving needs and circumstances in the mediation field. So these all are the functions that the mediation service provider is required to follow. Coming to the next section, that is section 42 of the Mediation Act. So section 42 of the Mediation Act lays down or empowers the Mediation Council to recognize mediation institute, and these institutes are designed to perform specific duties and exercise functions that support and enhance the mediation process. The section aims to establish a structural framework for the recognition and operation of mediation institutes ensuring they contribute effectively to the mediation landscape. The section, that is the mediation institutes, recognition involves evaluating and endorsing institutes based on their capacity to perform the designated duties and functions, and ensuring that only qualified and competent institutes are authorized to operate, maintaining high standards within the mediation community. Further, this section also enumerates that the mediation institute perform duties and exercise function as specified by the mediation councils. So basically, this section involved in assessment as to whether the mediation service provider is following the duties, and if it's not following, it may not be recognized by the mediation council. And until and unless the mediation council recognize, it may not be involved in mediation process. So this section ensures only qualified and competent institutes are recognized, and this section helps to maintain high standards and effectiveness in the mediation landscape. Overall, Chapter 9 of the Mediation Act 2023 is an instrumental in establishing a comprehensive framework for the operation and recognition of mediation service providers and mediation institutes. By defining these entities and their function, the Act ensures that the mediation service are delivered efficiently, ethically, and professionally. The recognition and regulation of the mediation service provider and institutes guarantee that mediators are accredited, facilitators are adequately provided, and the mediation process is supported by a solid infrastructure. By setting high standards and clear guidelines for operation of mediation service provider and institute, Chapter 9 reinforces the credibility and effectiveness of the mediation process. It ensures that the parties seeking mediation can rely on well-regulated and professional services, ultimately promoting the broader goal of peaceful and amicable dispute resolution. So with this, we hereby conclude discussion on Chapter 9 of Mediation Act 2023. Thank you.